Thank you. Ms. Slattery.
May it please the Court, Eve Slattery for Plaintiff Appellant Dr. David Ingalls, and I'm here this morning with Attorney Paul Sorrell. I would like to address two issues this morning. The first, that the Board improperly relied on evidence outside the record to revoke Dr. Ingalls' license. And second, that it was also improper for the Board to revoke his license based on two stale complaints, one 14 years old and the second 7 years old. And the third issue that we have raised in our brief, that the Board's decision is not supported by substantial evidence, I will rest on my brief, unless, of course, the Court has any questions on that issue. In this case, the Board specifically relied on harm that came directly from victim impact statements of two patients to revoke Dr. Ingalls' license. In its final decision and order, the Board stated, the pattern, extent, and severity of misconduct over time and the harm respondent has caused three patients is so egregious that it merits revocation of the respondent's license to practice medicine. And that evidence of harm was entirely outside of the record. Harm is not alleged in the statement of allegations. There was no evidence of harm introduced at the DALA hearing. In fact, when the Board tried to introduce it, the magistrate excluded it.
Didn't they give a victim impact statement, something like a victim impact statement?
They did, Your Honor, and they did so after the adjudicatory hearing at DALA, after the record had closed, and we had submitted objections, and the magistrate had issued a recommended decision. We filed objections, and then the Board notified us that we would be heard on our objections and on sanctions. In their directive to us regarding, well, let me back up. And at that hearing on sanction and on whether or not to accept the recommended decision, the Board did hear victim impact statements.
Now, the statute's been amended, as I understand it, to specifically permit this kind of statement. Is that correct?
That's correct. However, I would submit that the statute does not permit the victims to give testimony or present evidence about issues outside of the record.
So what you're suggesting is that the adjudicatory hearing itself then should include information about victim impact. Is that correct?
In other words, any evidence that the Board's going to rely on to discipline a physician. And as well, in this case, we presented the mitigating evidence at the hearing. So any evidence that the Board's going to rely on or that the doctor would rely on for his defense or mitigation should be presented at the adjudicatory hearing at DALA. And then at the sanctions hearing, when the Board is both deciding whether or not to adopt the recommended decision and what sanction, at that point the parties would be arguing about what has already been raised below. And I'd like to point out specifically in this case that the Board directed us that at this sanction hearing that they told us specifically the Board will not consider any matters outside of the record.
But excuse me, Chapter 112, Section 5 does say that before the Board's vote on final disposition, the Board shall provide the victim an opportunity to be heard. Why would they say that before final disposition that the Board should hear the victim impact if, according to you, it can only be addressed if it's part of the testimony in the hearing itself?
The problem with the way the statute could be, as would have been applied in this case if the statute was applicable, which it was not, is that the patients presented evidence about harm that was wholly outside the record. The Board relied on it to revoke his license, and that does not comport with Chapter 30A.
Although I take it once they've made their presentation, it is in the record. It's in the administrative record.
Right.
It may not have been subject to cross-examination, but it's in the administrative record.
Well, technically, the administrative magistrate closed the record in March. So at that point, it was officially closed.
Maybe that's terminology. I mean, for sure, the proceedings, the subsequent proceedings before the board become part of the administrative record.
That's correct.
So I guess it just depends on what you mean by the record.
Right, right. But even so,
I take, if I understand you correctly, and I have no, what you're saying is that there's a dollar hearing, there's a record that is generated in connection with that hearing, and that the board is constrained to look at what was before the dollar magistrate in making its determinations.
that's correct.
Both as to the facts, whether there have been ethical violations, and as to disposition?
That's correct.
Because in fact, but I take it that at this disposition hearing, which is after the dollar hearing, of course, the individual doctor can present evidence of mitigation and can't he?
But the doctor is constrained to present only evidence that's already been presented at the dollar hearing.
Oh, is that correct?
He's not entitled to now come in and bring, colleagues or other patients to speak on his behalf.
And is that what happened in this case?
That's correct.
So that at the disposition hearing, we'll call it that, I know it was a hearing which dealt both with the objections and whether the board would accept the recommendations, and also with respect to sanction. There was nothing presented in that context by the doctor that hadn't already been presented in the dollar hearing.
That's correct. I mean, he spoke on his behalf, but the mitigating evidence that was presented, the witnesses and an affidavit, was presented at the dollar hearing.
Under the current procedure, even though I take it the dispositional hearing is limited to issues that have been previously litigated, can you present testimony at the dispositional hearing?
The parties are constricted, or we were constricted to rely solely what's on the record. So basically, you can speak about, arguments about the objections or about.
So the only speakers at the dispositional hearing are the attorneys?
The doctor is permitted to testify, or not testify, but to talk at this hearing, and the board has permitted patients to testify as well.
Okay. To testify or to speak?
Well, when I say testify, it's not under oath, it's not subject to cross-examination, so I would characterize it as speaking before the board. Each side has 10 minutes. In our case, we had 10 minutes to both present our objections to the administrative magistrate's recommended decision as well as sanction.
So your argument is that that process, to the extent it brings in information outside of the dollar record, is a violation both of the board's procedures and a violation of due process.
That's correct. And we did object at this dispositional hearing and moved by motion to ask to the board to reopen the record so that we could cross-examine the witnesses and present rebuttal evidence, and that motion was denied.
Is there evidence? Did the board say, based on the victim statements, we reach the conclusion that we reach? Is there evidence that they actually relied on that?
There is, Your Honor. When the board issued its final decision, it stated the basis for revocation being the pattern, extent, severity of misconduct over time, and the harm respondent has caused 3 patients. And that was the basis for revoking his license. So they were specifically relying on the fact of the harm, and the only evidence of the harm was in these victim impact statements at the dispositional hearing.
Do you want to address the stale complaints issue?
Yes, Your Honor. The board's staleness regulation provides that, except where the complaint committee or the board determines otherwise for good cause, the board shall not entertain any complaint arising out of acts or omissions occurring more than 6 years prior to the date the complaint is filed with the board. And in this case, one of the complaints was 14 years old, and the second complaint was 7 years old. And the board, in its final decision, says that the board explicitly found good cause pursuant to the staleness regulation when it issued the statute of allegations in the case. And we submit that there must be a higher threshold than issuing a statement of allegations, or otherwise the regulation is meaningless.
Essentially, what we don't have from the statute of allegations is what the good cause was.
That's correct.
Was the board required to include that in any specific fashion in its allegations, or simply to have considered it prior to the allegations being filed?
The regulation does not provide for an explicit finding to be made in writing, but what it clearly provides for that the board has to consider the good cause and make a determination of good cause.
And in the board's final decision, didn't it, I don't have the wording right in front of me, but I thought it saw that it actually had included that in its final decision.
According to the board, the good cause it found was, actually, I'll quote what the board says, the board explicitly found good cause pursuant to 243 CMR 1.0316 when it issued the statement of allegations in the instant case.
Why isn't that enough?
Because we don't know what the good cause is.
Because, in other words, let me answer it another way. This regulation was promulgated in 1993. Prior to that time, the board's regulations about issuing statements of allegations was in place and did not change after the staleness regulation was promulgated. So, in other words, they already the standards that they had to meet for the issuance of the statement of allegations was already in place, and there needed to be a higher threshold in the staleness regulation to meet.
Well, in any event, the board doesn't tell me what its good cause is unless a court can't review the board's determination, which it might not be able to. How on earth would I know what the good cause is?
We don't know either, Your Honor. But I would submit that as a matter of law, there is no good cause in this case. There is no pattern in that the incidents occurred over a 13-year period. There's a 10-year gap between the first incident and the second incident. And under this Court's holdings in Fish versus Board of Registration and Medicine and the appeals court case in Commonwealth versus Jacobs, that huge extent of time is not sufficient to establish a pattern as a matter of law.
The regulation speaks about a complaint committee determining good cause before it can entertain a complaint, which is more than 6 years old. Is the complaint committee the same as the board?
The complaint committee is several members of the board that reviews complaints.
And do they also sit on the board that makes the final decision?
Yes, they do.
Okay. What do you say would constitute, what kinds of things constitute good cause?
I mean, one instance would be if there was some kind of perhaps if there's a justification for the delay, which there was not in this case.
Well, quite the contrary, the board might have found that there's a considerable body of evidence which is reflected in some of our law in other respects that victims of a particular kind of abuse are hesitant to come forward. In other words, it's not if somebody sat on the information and did nothing about it.
Well, actually, Justice Marshall, in this case, the patient A, the patient that occurred 14 years earlier, had reported it to the police. They did nothing, but then the district attorney's office waited 14 years to then report it to the board. So, in fact, with patient A, the Commonwealth was sitting on its hands.
Yeah, the Attorney General says that you would have to make I think he's saying that you would have to make a showing of prejudice, and that there is no prejudice in this case with respect to patient A anyway, because the doctor was basically involved in that investigation and even had met with patient A at the police station.
To be honest, I don't quite understand that, but what I would
Well, there's no. He was fully aware. It doesn't affect memory at that point. He was involved in this thing from day one.
So he was involved, but he understood that the charges were meritless because the Commonwealth didn't move forward with them.
Did not move forward.
Did not move forward. So, in fact, he had no idea that this was going to be resuscitated 14 years later. So the fact that at one point it was investigated by the police, I don't understand how that sort of erases the problems with 14 years going by and problems with memory and distortion and things of that nature.
Well, there was something in the, referenced in the Commonwealth's brief, and I haven't been able to go into the record to check it, but I assume, and there's a record cite on it, that the 1985 allegations at least resolved themselves by an agreement that the doctor would do certain things.
That was the patient's testimony. That was not...
That wasn't the police officer's testimony?
No, there was no testimony from the Commonwealth about those earlier dealings with patient A's complaint.
So that was simply patient A saying, my recollection is, let's see, patient A and her parents met the doctor, his attorney, and a police official at the Newbury Police Station, discussed the incident. After this meeting, patient A and her parents met again with the doctor, this time at the courthouse. On this occasion, Ingalls agreed to get psychiatric counseling and to have a nurse or a chaperone present during the examination of female patients. That was the evidence, at least at the hearing, right?
Well, that was patient A's testimony.
Okay.
There was also, testimony of Dr. Ingalls that denied that.
Okay.
Thank you, Ms. Slattery.
Thank you.
Mr. Porter?
Good morning, and may it please the Court. William Porter, Assistant Attorney General. I'll address the issues in the same order that my sister has.
Well, I wonder if you would just address the stale reports first. I mean, what's the evidence of good cause? I mean, how does anybody know what? I mean, you issue a regulation, you interpret the regulation, but you don't tell me how you've interpreted the regulation. So how can I review what you've done, whether what you've done is consistent with?
We would submit, Your Honor, that the discrete determination of good cause is not separately reviewable after the conclusion of the case. What this Court is reviewing is the Board's final decision in the case under the well-settled standards. The good cause determination is something that the Board has chosen to place upon itself, essentially an extra layer, a second look at complaints that are received more than 6 years after the incident. But it's not something that we would submit is separately reviewable. The Board also, for example, has to have reason to believe that certain things happened when it issues a statement of allegations. That's the general standard for issuing the original statement. Again, we would submit that's the kind of thing, those preliminary determinations that are really not subject to separate review at all at the end of the case. But, Chief Justice Marshall, in any event, we think they're clearly, even if it were separately reviewable, there's clearly good cause in this case. What you have here are three very similar complaints from adolescent females between the ages of 13 and 17 made against Dr. Ingalls for very similar types of sexual misconduct during private office routine, what should have been routine office visits when he was alone in the room with the patient. When the Board received those complaints, given their specificity, given their similarity, given that none of the patient victims would have had any motivation to fabricate their testimony, none of them had civil suits pending, for example, they all came forward voluntarily. If good cause were separately reviewable, and we say it's not, that it's plainly here.
Did these three complainants come through, how can I say this, sort of entirely independently, and all of a sudden, the Board receives complaints and links them up?
They came, as far as we can determine, they came independently. The complaint originally issued on patients denominated as patients A, B, and C. For a reason that's not apparent in the record, there was no evidence submitted for patient B at the hearing. One might infer that at some point she declined to testify, but we don't know. But as far as we know, those three patients all came to the Board entirely independently. Patient D, who was the subject of an amended statement of allegations that was added, she actually reported the conduct that she complained of to a cousin at some point in 2002. Her cousin later informed her of a story in the Newburyport, or a local paper, that of Dr. Ingalls. That following her becoming aware of that story, she reported her complaint to the Board. So they were all received independently. Patient D is a little bit different in that Although she reported the conduct to a close confidant, her cousin, she didn't report it to the board until she read the newspaper story. But from the board's perspective, clearly there was cause. And again, even though we don't believe it's separately subject to judicial review, if it were, I think there's no need for a particular detailed statement of the basis for good cause, at least in this case where it's obvious from the decision as a whole that good cause plainly existed. Otherwise, the complaints concerning patients A and D, which my sister has characterized as stale, the arguments related to those clearly fail. There's no, as my sister acknowledged, no explicit requirement of a finding. Even if there were, the board in its final decision did set forth explicitly that it had determined it had good cause. Dr. Ingalls was not prejudiced in the proceedings because he, in fact, challenged the complaints as stale both before DALA and at the final hearing before the board. Dr. Ingalls has raised, on the general question of staleness, a challenge, a more general challenge to the age of the complaints. He's categorized it as a due process claim. We would submit again that that claim was properly rejected and should be rejected by this court. When this court has considered that type of claim in terms of a physician discipline case, it's looked not purely at the age of the complaints, but rather at whether the board delayed in bringing the prosecution. That was the question it considered, this court considered in the Wang case. That was the question the court considered in the Aronoff case. Here, there was no undue delay before the board. It was approximately 2 years between the referral in December of 1999 and the statement of allegations that was issued in January of 2002. In the Wang case, the court held that 4 years was lengthy but not inexcusable so as to bar the proceeding. And in the Aronoff case, it was 3 years. I think here we're well within the standard of reasonableness. In any event, Dr. Ingalls has not shown any prejudice from the age of the complaints. As was pointed out in the earlier questioning, as to patient A, he was interviewed extensively by patient A shortly after she brought her complaint to the Salisbury police. That patient, whose complaint was the oldest in the proceeding, he clearly had reason to isolate that incident in his memory and to pay particular attention to his records respecting patient A. Patient D, who's the other patient who allegedly brings a stale complaint, which should be barred, was 13 years old at the time of the incident. We would submit that there would be no appropriate reason to bar the complaint of a 13-year-old, which was made when she was 20, some 7 years later, but only 2 years after she reached the age of majority. Generally, the court has come out strongly against recognizing laches as a bar to the enforcement of a public right. That was the holding in the Wang case. That certainly would apply here, given that this proceeding is not penal. It's to protect the public health. And for that reason, the court has seen that in the due process balancing, the protection of the public health is paramount when considering the contours of the due process clause in physician discipline proceedings. Dr. Ingalls asks the court to recognize laches. That would be a major reworking of the law. We would submit that the court should not do that, even if certain other states, such as New Hampshire, have.
Let me tell you what troubles me, not about that issue, but about one of the issues you haven't talked about yet. And it's actually two issues combined into one. First of all, as I understand it, at the DALA hearing, the board, the prosecutor, or what's the name?
It's referred to as complaint counsel.
The complaint counsel attempted to introduce evidence through the victims of harm, and that was excluded as being irrelevant. But then the board has a hearing on whether or not to accept the recommendations of the administrative law judge and permits that very evidence to come in. And indeed, I think it's a fair reading that that becomes part of their finding. I mean, they find that there was substantial harm over a long period of time, something that hadn't been litigated before the board at all. But A, the doctor had no notice that those witnesses were going to be there. B, no opportunity to cross-examine them. It is a little troubling, don't you think?
Respectfully, Your Honor, we don't believe it's troubling at all. I think the the
The doctor
process.
was, not only did he have no notice that they were going to be there, his notice was that he should be prepared to argue only what was on the record in Dala.
Well, Dr. Ingalls had notice in a letter. It's at page 421 of the administrative record. Part of that letter says that complaint counsel, on page 421, may use all of the time that she has, or may give some or all of the time to the complainants. So on page 421, we see that plainly the board has given notice to Dr. Ingalls' counsel that the complaining patient victims will be permitted to speak at the dispositional hearing. So there's clearly no lack of notice. And to your larger question, Justice Cordy, we would submit that, in fact, the process proceeded exactly as it should have. This Court's cases make clear that harm is not a required element in finding a violation of the physician disciplinary statute.
Correct.
And so the Dala magistrate did not allow evidence on that. The Court has also made equally clear 2 times in this calendar year, in the Weinberg case and in the Coburn case, both cited in our brief, that the final hearing is a dispositional hearing. It's a hearing that's not an adjudicatory hearing. It's not for fact-finding. It permits both the physician and the complainants to address the question of what the sanction should be. Dr. Ingalls is permitted to present a mitigation statement, and the complaining witnesses at the time of this case, by practice, were permitted to do it. Now, by statute, they're permitted to make victim impact statements. If Your Honor looks at the board's decision, it actually appropriately separates these 2 functions. It's in the addendum to the blue brief in this case. It's also in the administrative record. We see that the evidence concerning misconduct is all set out in the factual findings of the magistrate. That was heard before Dala. That's the record. And then we see separately at the front, under the heading of sanction and order, that's the only place that harm is mentioned. And harm, the board found that there was harm. This is page 2 of the decision in the addendum. The harm was so egregious that it merits revocation. So the board only considered harm on the question of what should the penalty be, what level of sanction should be found here, should be imposed. We would submit that that's exactly the way it should play out, and that the board very carefully and appropriately observed really the dual functions before it. Step number 1, make a determination, should the Dala magistrate's recommended findings be adopted. That's what the board did. We know that because those all follow in that section of the decision. Isolate the question of harm as it comes in through the victim impact statements at the dispositional hearing, so as to inform the question of what should the sanction be. That's the only place that harm appears.
Does that mean that they took into consideration the victim impact statements?
I think
disposition.
I think ultimately we don't know what influence they may or may not have had. But certainly if they were received and heard, there's certainly the possibility that they considered them, and I think that would be appropriate.
What are the harm respondents have caused these patients is so egregious? I mean, other than the victim impact statement, what other evidence is there?
Well, I was actually going to address that right now, Chief Justice Marshall. What I think Dr. Ingalls would have to show error here is that something happened at that hearing that absolutely turned the board's head around. And we would submit that the nature of the evidence here, on its face, the sexual exploitation of adolescent females in the medical examination room, on its face would easily result in an inference of harm by the board, even if no victim impact statements were received. I think that would be a more than appropriate conclusion.
Explain to me the process here. Was the doctor offered an opportunity to respond? Because obviously this evidence, and it was evidence, I mean, this is whether it's sworn testimony or unsworn testimony, people are saying, I was harmed, and the board is considering it for something. Was the doctor given any opportunity to respond to that?
We don't have a transcript of the dispositional hearing. The board's letter, which again is at page 421 of the administrative record, informs counsel that there won't be a stenographer there, but they can bring one if they want to have a transcript. So we, in this case, are really hampered by that fact. And I think for that reason, we don't know exactly how it proceeded. Dr. Ingalls did file a motion after the dispositional hearing challenging the receipt of victim impact statements by patients A and C. So the issue was clearly and separately considered. We also know that the board agreed to take a recess during the dispositional hearing to consider his objections to the receipt of the victim impact statements.
Well, what would have been the I'm sorry, finish your thought.
No, just simply, even without a transcript, the record does reflect that the issue was carefully considered.
Going into the dispositional hearing, what would have been a reasonable range, expected range of sanctions that Dr. Ingalls would have expected to have imposed on him?
If the findings were adopted.
Yeah.
I would have a difficult, since I don't practice in that setting, I would have a difficult time saying that with certainty, but I think he would reasonably expect a very serious sanction, given that the findings were of sexually inappropriate touching in various ways with adolescent females alone in an examining room. I think he could expect a severe sanction, including revocation. I think it's reasonable.
What would have been reasonable at the low end? Any idea?
I couldn't. With all due respect, Your Honor, I couldn't say what that is.
Okay.
Even the cases in this court that have upheld revocation of physicians would make it clear that many times the court has affirmed revocation where sexual misconduct is at issue. In this appeal, Dr. Ingalls doesn't claim that his conduct doesn't rise, as found by the Dalla magistrate, doesn't rise to the level of a violation of the statute. He doesn't take that approach, even if he's sought to challenge certain of the evidence. So I think what we see is that the proceeding went exactly as it should have. The evidence was considered before Dalla. The board was permitted to hear from the patient complainants. Both in Weinberg and Coburn, the court made that clear. And the Weinberg case makes clear that if one wants to raise this type of due process issue, they need to present evidence of prejudice. Dr. Ingalls simply has not done that. He hasn't shown any particular prejudice or that it was highly likely that the board did something completely different than it would have done by receiving statements which would certainly not be unexpected given the serious misconduct that was testified to at the Dalla hearing, where both patients A and C were cross-examined extensively by Dr. Ingalls' counsel.
Thank you, Mr. Porter.
Thank you.
All rise. Hear ye, hear ye, hear ye. All persons having anything further to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting in Boston within and for the Commonwealth. At present apart, the sitting of this court is now adjourned. God save the Commonwealth of Massachusetts.